the Honorable High Court has granted interim order.
There is some confusion. There is a FCSA also. In FCSA, remand has been made, wherein it has been granted in respect of FCSA, who had also been continuing on contractual basis for a long period of time. I had placed the orders passed in FCSA, which your Lordship had taken at that point of time, and passed the orders. Remand has been made in respect of FCSA. This was earlier disputed and a second petition after withdrawal. After withdrawal, a second petition has been filed. Therefore, it is here. The Honorable Supreme Court, in the case of.
You tell first about the facts of this case.
Yes, that's one thing. I was starting from there only. NVS Navodaya Vidyalaya Samiti came into existence in 1986. After that, various institutions, there are more than 600 institutions which are running all over the country, in which there have been students who are imparted education without any charge, free of cost, and even school uniform and fees and food is also provided by the government. What had happened, in the term of this, there had been engagement which were required for all teachers and other things. They have not proceeded for having a regular engagement, but they have proceeded to make engagement on contractual basis for a long period of 20 years approximately. And in between, the Honorable Supreme Court in a case had passed an order, in which it was found that various students were committing suicide. Various students were actually having serious problems, That's the judgment of the Supreme Court, University of Kerala versus Council Principals, in which it was directed. These committees laid down certain guidelines to direct where Supreme Court had made mandatory for CBSE to have school counselors on post on every school. But after this judgment of 2009, the post of counselor was created. These people had been later appointed as on the post of a counselor, wherein the appointment initially was given for a period of 5 years. It was 10 months contract, but considering that they had a continuous requirement in terms of the Supreme Court, the appointment was given. What happened, my lords? In between, some of the appointments which were granted to these people were not extended and they had been terminated. Then we had filed this petition here before this Honorable Court, and since there is a direction given by Honorable Supreme Court, accordingly the post has been created.
We are considering this OA number 1572. Please come to your prayers. Page number 62. Page number 63 para 8.
Yes. Set aside the order of termination 26/2022 of the applicant number 135789. 8, 10, 11, so and so, and direct the respondent number 2 to reinstate the regularized services of the applicants.
So at least these applicants who have been numbered by you, they are no more in service.
These applicants have not been continuing in service, whereas the appointment initially was given for a period of 5 years. Definitely.
But they are not in service.
Yes, apart from that,
just a minute, sir. One by one, sir. What kind of stay can be granted to them?
There are other people also.
Number 2, sir.
In all, there are 36 people. Out of that, 18 were earlier taken out of the job.
You have not. I have gone through all the order sheets on none of the dates you have pressed for any grant of any interim relief. If you are having the order sheets, you can see why you pressed so much only on the last date of hearing, that is yesterday.
I will definitely say, we have tried, but your Lordship said we consider that later. And after that, notice was issued, what happens really when it is an opposite party, they always insist, we file counter affidavit, we file all these things based on record. That's what it has happened. We kindly see.
No, sir. Judgment, the little knowledge of law which I am having, says that one should be first very clear on the facts. After that, one should know what is the relevant rule or a scheme on the subject. And judgments come to assist the court only for the reason that in such facts and circumstances, how the things have been decided by a competent court of law. Judgment is only for that purpose. Judgment is not legislation. So now you see, sir, your case was listed on 29th May 2023. There was no representation on behalf of the applicant. Thereafter, the matter comes on 11th July. On that day, the applicant has requested, and even without notice to the other side, on the very first day, you have been saying that the other side used to take adjournment and all that. No. The very first day, even without having his consent, we allowed the application seeking continuation of delay. Next, even without examining everything in detail, we have allowed your application seeking exemption, of course subject to just exception. Joining application we have allowed, and that we can withdraw anytime. How all the applicants are similarly placed, we have shown to you that one batch of applicants are those who are no more in service. Another batch of applicants are who are still in service. So all the applicants are not similarly placed. Number one. और सर जुलाई में नोटिस किया, next date only one date is there coming after that, 4th September, none for the applicants. Of course, Mr. Shukla, you appeared thereafter. Counter reply on the very first day is on record. You are seeking time to file. Both of you are seeking time to adjournment. And on 10th January, the matter has been listed for 8th April. And on that very day, at your request, we have said that no matter is at serial number 94. However, at your request, the matter has been posted to 21st May 2024. How the matter came yesterday?
Removing an application for early listing.
Where is that application, sir? कई बार होता है कि हमसे भी गलती हो जाती है, जब काफी सीनियर और काफी आप जैसे एक्सपीरियंस वकील आ जाते हैं तो हम लोग इन्फ्लुएंस हो जाते हैं कि आपने जो कहा होगा सही ही कहा होगा. लेकिन काफी एक्सपीरियंस काउंसिल के आने से हमसे अगर कोई गलती हो रही होगी तो ठीक हो जाना चाहिए. ये नहीं होना चाहिए कि हमसे और गलती हो जाए.
We are also learning at all stages.
What is your prayer, sir, in this submit?
It was only for posting the matter on early date.
So, pass and listing the original application on some early date for disposal. What is the date, order of the last date? कल क्या हुआ था? क्या कल का ऑर्डर शीट क्या इसमें नहीं लगा है? देखो
ये कोई नंबर है लास्ट नंबर आ गया.
देखो कल का ऑर्डर
1572.
आप हमें वैसे ही बिना फाइल खोले हुए बता देते हैं कि ये एप्लीकेशन जो है अर्ली डेट के लिए लगा हुआ है. आप कह रहे हैं कि अगर मैंडेट है आपके ऊपर कि आपको इंट्री ऑर्डर पास करना है, तो हम भी तो डरते हैं कि अगर मान लीजिए सुप्रीम कोर्ट ने हमें डायरेक्शन देना होगी तुम आज इंट्री ऑर्डर दो, हम अगर नहीं दिए हमारा कंटेंट आप तो अपना संभाल लेंगे, हमारा कौन संभालेगा कंटेंट? हम तो बैठ गए कि हाँ भाई अगर कोई डायरेक्शन किसी ने दे रखा है सुप्रीम कोर्ट हाई कोर्ट ने तो पहले सुन लेते हैं.
सिर्फ ये है कि जैसे एफसीएसएस में जो हुआ है कि यहाँ मैटर अगर
ये बताइए, आप बताइए, अब तो हमने फाइल पढ़ ली, अब बताइए डेट कौन सा दे दें आपको? Today not matter is not listed and we can pass the order. The date is 20th May 2024. No early hearing is required.
Yesterday the
Matter is listed for
early hearing list application was listed yesterday.
So
And in which your lordship had passed the order.
what ये लिखा है
Listing today.
लास्ट नंबर है.
That is how it is listed as item number 72 today.
15 बात है.
हाँ है नहीं है इसमें दिखा दो ना मेरे को. प्रिंट डाउन अच्छा पहले दिखा दो. मिल गया अच्छा रफ टाइप का दिखा दो कोई
प्रिंट आउट
या पढ़ दो क्या लिखा है उसमें. पढ़ दो ऐसे छोटा ऑर्डर
Heading number 1544 is it? By way of the present amendment application.
Amendment number?
1544 of 2024.
Yeah.
By way of the present amendment, the applicant seeks early hearing in the OA. Issue notice interesting running conflict to respondent as such notice. For the reason given that view of the council appearing for the respondent and is allowed to the extent that will be listed for consideration and applicant's paper grant of interim relief and or final decision.
Check down. The MA was, the matter was earlier listed. Sorry, that by order dated 8th April 2024, the matter was scheduled for hearing on 21st May 2024. During that storm, subsequently, amendment number 1544 of 2024 was filed on behalf of the on behalf of the applicants, which was allowed by order dated 29/4/2024 to the extent that the OA be listed for consideration on applicant's prayer for grant of interim relief and or for final disposal on 30th April 2024. Mr. Shukla, learned counsel appearing for the applicant's presses for interim order and or a final decision in the matter. There is no representation on behalf of the respondents. It is 1:55 now. At 3:30, there is another bench. After 3:30, this bench is not available, as one of us is having a special bench. That's all. Admittedly, pleadings in the OA are complete, and earlier also the matter was listed for final hearing. In the facts and circumstances, we are of the considered view that the matter can be considered for the matter can be adjudicated finally. In the interest of justice, let the matter remain on board.
In case if tomorrow we are disengaged, regularization here should not. My only contention.
सर आपको से आपका हमारे माइंड में तो कुछ भी नहीं, हमारे माइंड में तो कुछ भी नहीं था शुक्ला जी। हमने आपसे प्रेयर पढ़ के बता दिया, आप में से ऑलरेडी हाफ डजन लोग। सर अगर देखिए, हमने कोर्ट से यही एक्सपेक्ट किया जाता है कि कोर्ट के माइंड में जो सही गलत हो ऑर्डर पे आ जाना चाहिए। ये नहीं कि बोल कुछ रहे हैं लिखवा कुछ रहे हैं। हमें जो समझ में आया हम
बीच में मैंने टोका नहीं तो शायद मैं पहले ही ड्राफ्ट कर चुका था।
नहीं, आपने कोई नहीं पूछा। आप कितने जॉली मूड में दैट आई डोंट नो, बट आई एम वेरी कंफर्टेबल।
What I am submitting today, in case today we are all disengaged and the prayer be for regularization shall not stand. So ultimately this matter will be finished. Then after we will have no remedy because it was a contractual appointment at this stage. Let's kindly turn to page 130 of this particular page.
सर हमने तो केवल दो
Just simple.
सर आपसे हम दो बात, अब तो फाइल बंद करके आपसे मैं पूछ सकता हूँ कोई बात, मैंने क्योंकि पढ़ लिया फाइल जरूरत पर। आप ये बताइए, फाइनल हियरिंग तो ओनली फॉर द रीजन if on 2 occasions the learned counsel for the applicants were not there, we have not dismissed the OA. Only for the reason that the learned counsel for the respondent was very much here yesterday, but today somehow he is not here, and that too at 1:55, which is lunch time. We are not going to pass any adverse order. Take it from us. Second, you are yourself saying that all the applicants now have already been terminated. Which kind of interim relief we can pass?
They are not. Today is 30th of April. Today is 30th April.
Sir, 50% of them were already terminated. No?
Yes.
Read your prayer. Why were not?
Out of this 18 people, 7 have been taken back also.
हमारे वजह से
11 people.
because of not our order
No, they have been taken back otherwise also.
by the government, na?
Now, Mr.
If the government
turn to
has taken
130.
back their terminated
Well,
persons.
just one page which I am requesting your lordship to
Sir,
kindly
हमने
come to
order
condition.
कर
F
दिया.
is only
We will
for 5
take up
years
this
engagement.
matter. We will take up this matter tomorrow. That's all. And if without, you should appreciate that department. That despite there being no interim direction or any final direction, if they have themselves taken back 7% in job during pendency of the OA, you should say thank you to them that yes, they may take other persons also at their own. And we are very much on the job. We are even not adjourning the matter. At least your MA we have allowed to the extent that the matter is being taken up on early date, and that is going on day-to-day basis. And for you, we are sitting during the lunch session also. What more we can do, sir? But we will not take adverse view only for the reason that your friend is somehow not present for 30 minutes or 40 minutes. Right, sir? Tomorrow will
I
be.
protect the notice of the court. My duty is over there.
And otherwise also, Mr. Shukla, you know better than us, you should not be worried. If your OA is pending and tomorrow they appoint somebody, they will have to make a clause in that appointment order.
I will show what is happening.
Hmm.
It is just because these people who had been continuing on contractual basis in these schools. Well, not only this, FCSA, many other teachers, they are not actually taking any regular post also sanctioned for it. And they are running the entire institution paying a meager salary. So everybody is at the mercy. These people have come approach this honorable court seeking a regularization of what is happening.
सबसे ज्यादा आपके साथ दिक्कत नहीं है, आपके क्लाइंट के साथ दिक्कत है.
Yes, some of them are touching 15 years, working for 25 years.
आपका कोई आदमी 15 years में नहीं आया. कब आप लोग पढ़े?
अब कम के हैं मेलर्स.
कब से आप अपॉइंट हुए?
2019 से. I'm not saying.
19 से अभी 5 साल नहीं हुआ सर.
वही आपको 113 पे जो दिखा रहा था 5 साल का इन्होंने अपॉइंटमेंट मेंशन कर रखा उसमें. और उसके बीच में टर्मिनेट किया तो we came here to this honorable court मेलर्स.
नौकरी अगर लॉ कहता होगा तो मिल जाएगा tomorrow.
Very grateful. I really apologize. Whatever.
You are having license for that.
License.